When I represent contractors on commercial construction projects, I'm always happy to see them use the A101-2017 flagship owner contractor agreement, where the cost of the work to be paid is a stipulated contract sum, a fixed contract price. I think that there's a lot of reasons why contractors who are looking to avoid disputes may prefer the A101-2017 for that fixed contract sum reason. It tends to be less likely to provoke disputes on the project. But the basic business deal, when you have a fixed contract price, it involves contractors winning when they're able to bring the project in. I'm talking about their actual costs in under the adjusted contract sum. Adjusted, of course, meaning that there will be change orders, the fixed contract sum will move. But if you, as a contractor, agree that you're going to get paid $1 million for a project and you can complete it for $900,000, great for you. That's how you win. That's how you make more money. If it costs you $1.1 million instead of $1 million, that's how you lose. Of course, this particular contract document, the A101-2017, is not appropriate on design build projects where a contractor is acting as a design builder. It's not appropriate where the contractor is acting as some kind of a construction manager, whether it is at risk or just as a construction manager as advisor. The A101-2017 is the flagship AIA owner contractor agreement where the contractor will be paid a fixed contract sum. Obviously, if you are a contractor and if you're going to give a fixed contract sum to the owner, then you obviously have to have complete enough architectural and engineering drawings so that you're comfortable giving that fixed contract sum, which of course can move with change orders. We all know that it's the adjusted contract sum at the end of the project that you're going to be paid, but you're not going to give an owner a fixed contract sum out of the gate, and you're not going to specify a completion date if you don't have drawings that are complete enough. This obviously implies that the owner has reasonably complete architectural and engineering drawings, which implies that the owner has been working with the design team for some time, which implies that the A101-2017 is an appropriate document when the owner contracts with the design team. The architect and the engineers over here, they get their drawings complete enough so that when it comes time for the owner to separately contract with a contractor in a document like the A101-2017, what we're talking about now, there are complete enough documents so that the project can have a fixed contract sum entered in and a completion date entered in right out of the gate. This is a great document to use, particularly if you are in a design, negotiate, build situation. If you're a contractor, you're obviously going to prefer negotiated pricing with an owner if you're the only suitor that's in the running for the job than if you are involved in a beauty contest and bidding. But you can use the A101-2017 in a design bid build situation or a design negotiate build situation. Obviously, contractors are going to prefer the latter. Something that's important for contractors to understand when they're using the A101-2017 is you can't just read that document alone and assume that that embodies all of your obligations as the contractor. And that's because the A101-2017 incorporates by reference a 38-page document known as the A201-2017 General Conditions. And so if you are a contractor and you're working with an A101 and you negotiate with an owner and you sign it and you never bother to put your hands on a copy of the A201 General Conditions, you're really going to be going into the contract and the project with one eye closed. Because the A201 General Conditions is a document that it must accompany the A101-2017, full stop. There's no way for you to just have the A101 govern without the A201. So if you're a well-advised contractor, you're going to get your hands on it, you're going to flip through the 38 pages, and you're going to see that there are hundreds of references to contractor in that document. There are hundreds of references to owner, and there are hundreds of references to architect. And that's because the A201, which is incorporated by reference into your A101 contract document, talks about how the owner, the contractor, and the architect are going to play nicely in the sandbox together. That's the function of the A201 General Conditions. It talks about the relationship between the owner, the architect, and the contractor. That's definitely something you're going to want to take a good look at if you're the contractor, and that is entirely separate from the A101-2017, which is the main focus of this video, which again just embodies the business deal between you, the contractor, and the owner. Obviously, any off-the-shelf contract document, whether it is a consensus docs document, whether it is an EJCDC contract document, an AIA contract document, is going to necessarily be a relatively up-the-middle contract document that is not favoring one party or the other. Obviously, these documents are for sale, and the industry groups that write them are not going to want to create a document that's dead on arrival and will never be used because it favors one party more than another. And that is why, if you are a well-advised commercial construction contractor that is using the A101-2017, you're going to need to think about what sort of edits that you will want to put in there to protect yourself as the contractor that are not part of the standard AIA agreement. Now, I certainly have my version of the A101-2017 for when I represent the owner. I've got a version of custom edits for when I represent the contractor. There are definitely some things that overlap. There are concentric circles here because I don't like to think about the owner and the contractor as being at war with one another in terms of dispute resolution and having clarity on price and schedule and what comprises the work and getting the contractor's clarifications and exclusions in there. There's a lot of important stuff where the owner and the contractor are going to see eye to eye on. And regardless of who I represent, I'm going to be striving for the same thing. But there are absolutely contractor-sided edits that I'm going to try to get into the agreement when I represent the contractor and I'm negotiating on behalf of the contractor against the owner's attorney when we're putting together an A101-2017. So let's go through the 9 articles of the A101-2017, and let's talk a little bit about what the different articles are and how I might edit them if I represented a well-advised commercial contractor on a construction project. Article 1 of the A101-2017 talks about the contract documents, and obviously contract documents with a capital C, capital D is a term of art. It embodies a wide variety of documents that will describe the contractor's obligations for executing the work. This is going to include not just the A101 and not just the A201 general conditions, but it's going to list out the drawings and it's going to list out the specifications and any addenda and any change orders and any exhibits to the contract. And this is an opportunity for you to have your clarifications and exclusions document as the contractor worked into the contract document. So, there are words that I like to add in to Article 1, which talks about the contract documents when I'm representing a contractor. There's also room to attach some exhibits to the A101-2017 if you're a well-advised contractor and you're looking to make sure that the contract documents appropriately describe the scope of work that you're going to be executing. And I want to be careful about this. I'm a real big fan of contracts which are very clear in terms of the parties' obligations, but I will say that there is room for a little bit of tactical ambiguity in certain circumstances if you're the contractor. And so there's a lot to think about when you're looking at Article 1 of the A101, a lot to think about in terms of what sort of custom edits a well-advised contractor might consider implementing. Article 2 of the A101 talks about the work of the contract, work being also a term of art, capital W, work. The work is code for the obligation of the contractor when it comes to the construction that's required for the price. The default language in Article 2 describes execution of the work, as being synonymous with building the entire project. It may be the case that not every aspect of the entire project is fairly described as the contractor's work. A well-advised contractor is going to consider carefully whether some work that comprises the project ought to not be part of their capital W work as defined in Article 2 of the contract. There are certain times when things that an owner wishes to have in its project are going to be executed by others. And so you need to carefully consider whether there's aspects of the project that need to be excluded from the definition of work, capital W, because these are things that are going to be done by others. For example, if the owner or the architect or an interior designer is going to purchase something, procure something, who's responsible for making sure that it gets to the site? Who's responsible for making sure that it's not just like dropped off in the rain? Who keeps it safe? Who installs it? Who warrants, the performance of that item? In the event that those things are late, what impact does that have on schedule? There's a lot to consider here if you're a well-advised contractor and you want to think about how to appropriately qualify the term of art, the work, the capital W work of this contract when editing Article 2 of the A101-2017. Moving on to Article 3, which addresses the date of commencement and the date of substantial completion, which are the bookends, the start and the end date for the project. There's absolutely room in the A101-2017 for a well-advised contractor to include some language here that will talk about delays and extensions of time that may speak to when is a delay excusable, in the sense of when does a contractor get more time, when is a delay compensable, meaning when would a contractor get paid more money in addition to getting more time. And there's room for inserting force majeure type language, which would talk about circumstances when either the owner or the contractor would get more time to complete their performance under the contract in the event of certain delays, which are neither party's fault. There are other places in the A101 and the A201 where you can stick some of this language, but a well-advised contractor is going to want to get it somewhere, and Article 3 of the A101-2017 is one option. If we move on to Article 4, contract sum, obviously contractors are very interested in making sure that the contract sum, the initial contract sum that they're going to insert in the contract when they first sign it is spelled out with clarity. I like to joke that contractors only edit sentences in contract negotiations where the sentences have dollar signs on them. That's actually not universally true. A well-advised contractor is going to want edits throughout the A101-2017. But even those contractors that like to go as light as possible and they're only focused on sentences where there's dollar signs, Article 4, which addresses the contract sum in the A101, is certainly part of the contract that's going to have a lot of dollar signs in it. A couple things that a contractor is going to want to think about is not just specifying what is the contract sum, and what are the unit prices and allowances, and the sort of the nuance that goes into the contract sum, but also Article 4 is a place that a well-advised contractor may consider additional language around general conditions or general requirements dollars, specifically under what circumstances would they be entitled to get more of these dollars, which tend to be time-based. When would, if there's a change order granted, would it be appropriate to not just extend the time for performance and the contract sum, but the parts of the contract sum that are intimately tied to time, temporary heating, construction fencing, trailer, rental equipment, the value that the owner is going to pay per month for the dedicated labor of the general contractor's employees. So thinking about not just the contract sum in terms of scope and dollars, but also general conditions and general requirements, and when would you get more of those if you are granted a change order is something that is worth considering if you're a well-advised contractor. You're also going to want to think about price escalation. What happens in this post-COVID era, in this disrupted economic environment where there's a lot of talk about tariffs right now. There's a lot of talk about things that could have an impact on commodity prices, the price of steel, the price of lumber. Well-advised contractor is going to think about edits in Article 4 that might address under what circumstances would they be entitled to an equitable adjustment of the contract sum, even if the scope of the work doesn't change. These are things that a well-advised owner will typically fight hard against, but there are ways to write words in Article 4 of the A101 that will generally pass the scrutiny of even the most hard-nosed owners' attorneys, that will speak to industry-wide shortages of labor or material, again, not project-specific, but industry-wide, or industry-wide escalation of commodity prices that are beyond the reasonable control of the contractor, that is going to cause substantial inequity to the contractor by increasing its cost over the time required for the execution of the work. When I'm an owner and I am confronted with a contractor that's asking for this, in this time of uncertainty, I'm usually willing to grant them a little bit of wiggle room. When I'm representing an owner, I'm still not going to let that clause go too far. But I think it's a missed opportunity for a well-advised contractor to overlook the possibility of adding certain language in these uncertain economic times into Article 4 of the A101, which speaks to the contract sum, to address what happens in the event of price escalation, that is industry-wide. Under what circumstances would it be appropriate to give the contractor an equitable adjustment? If we move on to Article 5, which speaks to payments, there's a lot that a well-advised contractor is going to consider. Will the contractor require an initial payment from the owner before work will be started? Is this something that is required in the event that the contractor is going to have to make some early procurement of log and lead time items? And would the initial payment be required even if there isn't a need for them to make an initial outlay that's going to be substantial for the procurement of certain log and lead time items? Would an initial payment be something that a contractor would require before they're going to commence work, before the date of commencement that starts the timing that the contractor has from the date of commencement to substantial completion? And in the event that an initial payment is going to be required by the contractor, is that something that would be refundable to the owner under certain circumstances? And if so, what would those circumstances be? A well-advised contractor may also look at Article 5 as an opportunity to think about whether it's appropriate to diminish the role of the architect in the payment process. If you are a contractor who's working for an owner that hired the architect only to produce construction documents and not to play a role in construction administration, a well-advised contractor is going to want to excise a lot of language in the A101-2017 and indeed also the A201 general conditions document that puts the architect right in the middle of the payment process. Retainage is another important issue for a contractor to address in Article 5, or at least to consider addressing. If there will be retainage retained by an owner, also known as retention, are certain things exempt? Are general condition costs exempt from withholding of retainage? Is the contractor's fee exempt? What about material or equipment orders that require the contractor to make payments to vendors or suppliers perhaps years before substantial completion? What about the release of retention or retainage to subcontractors whose work is going to be done well before substantial completion, maybe years before? This might be somebody who digs a foundation or pours a foundation or does civil work. When would retainage be released to the general contractor or to subcontractors? And what is the relationship between the retention of retainage and final payment and completion of the punch list and certificates of substantial completion or certificates of occupancy? A well-advised contractor is going to think about whether it's in their interest to address some of those issues in Article 5 payments. Also in Article 5, will the owner require waivers of mechanics lien that are trailing by 30 days? In other words, does the contractor give the owner a lien waiver for the payment that the owner made last month? Or will the owner require current mechanics lien waivers where the contractor will have to give it to the owner this month before the owner actually makes the payment? Sometimes owners' hands are tied. Sometimes they've got lenders that require title insurance or requires an escrow agent to be involved. Sometimes current mechanics lien waivers need to be handed over. In circumstances like that, there's some custom language that a well-advised contractor may want to consider adding in to Article 5 to protect them. And certainly there's a logistical issue here because it's often the case that subcontractors are going to be loath to provide current lien waivers for a payment that they've not yet received, particularly because they lack the sort of relationship with the owner that the general contractor does. And whereas the general contractor might be willing to give a current lien waiver, perhaps a subcontractor won't. It's also worth considering putting into Article 5 a procedure that would specify how an owner would dispute a contractor payment application. Now, a lot of contractors might be thinking, why would we want to include something like that? That doesn't really help us. But there are absolutely contractor-sided concepts that would be appropriate to stick in Article 5 that would address the circumstances in which an owner would be able to dispute a payment application in ways that are fair to the owner and the contractor, that would tend to avoid end-of-project surprises or people disputing invoices that may have been submitted long ago. And of course, as I mentioned in some of my other videos on the A101-2017, no AIA contract, no manuscript contract anywhere that's available for purchase is going to be state law specific. So a well-advised contractor is going to want to conform Article 5 payments of the A101-2017 to the requirements of state law. This might be prompt payment, it might be retainage, it might be the Mechanics Lien Act. So there's a lot of edits that a well-advised contractor is going to think about putting into Article 5 payments, even in sentences that don't, include dollar signs in them. Article 6 talks about dispute resolution, and the A101-2017 has an opportunity for the contractor to check litigation is the binding form of dispute resolution or arbitration. If neither box is checked, the default is litigation. There's room for contractors who are interested in early cost-efficient dispute resolution and not having to be involved in arbitration or litigation to put some language into Article 6, which would tend to promote early and cost-efficient resolution of disputes. This is certainly in the interest of contractors, but also owners. So this is where there is a lot of overlap between the way that I think about how to edit Article 6, regardless of whether I'm representing the owner or the contractor, but something contractor specific that a well-advised contractor may wish to consider when looking at Article 6 is the potential elimination of the initial decision maker requirement. And the initial decision maker is something that I address at length in other videos. If we move on to Article 7 of the A101-2017, which talks about the circumstances in which the owner and the contractor can either suspend or terminate the contract or the project, it's worth considering, if you're a contractor, what will you be paid if the project is suspended and then restarted? What will you be paid if the project is terminated for the owner's convenience? Bearing in mind, that you're not going to have the opportunity to earn a fee on work that you committed to perform, and perhaps you passed up on other construction projects for other owners, and you dedicated your staff to this particular one. If you don't get the opportunity to execute the work that you expected, and you're not going to get the fee that you expected, and you have to keep your people busy and transition them to other projects, there are concepts to consider, including in Article 7, that speak to those issues. And of course, if you get terminated for cause, then there are absolutely some concepts that a well-advised contractor is going to want to consider getting into the A101-2017 to make sure that their interests are protected in the hopeful event that litigation can be avoided, but in the event that there is litigation, to make sure that at the end of the day, you're at least able to recover for the good work that you did to that point. Article 8 of the A101-2017 is designated as miscellaneous provisions by the AIA. This is really where I think, to a great extent, I earn my money when I represent commercial construction contractors in negotiating an A101-2017, because there is a plethora of custom edits that I would stick into this miscellaneous provisions section. There are all kinds of concepts about state law, protection of adjacent landowners, so many things to consider in terms of warranty. What kind of warranty, what duration, will it be provided by the contractor, will it be provided by the subcontractors? What is the relationship between the warranty that the contractor provides and the ones provided by subcontractors and material suppliers? Will there be indemnity? Will it flow in both directions? What will trigger the indemnity clause? Will it be when something explodes or collapses, or will it be different sorts of disputes? Will the insurance be matched up will the indemnity be matched up to an insurance policy so that the contractor's obligations are coextensive with what their insurance is going to provide? If there's an alleged breach or a defect, is the contractor entitled to cure? What does the right to cure clause say? What's the duration? Does the owner have a right to cure? There are many edits that a well-advised contractor might consider putting in with respect to environmental concerns. There's a bunch of insurance concepts that could be added by a well-advised contractor into Article 8. Perhaps a statement that clarifies that they're not going to provide any professional services, which is something that requires some nuance. If MEPFP, for example, or any other element of the project is going to be provided by design build subcontractors hired by the general contractor. There's room in here to address in Article 8 of the A101-2017 administration of the construction contract. And, what are certain basic expectations that the contractor has in terms of the way that the owner and the architect are going to conduct themselves as they're doing all of the things described in the A201 General Conditions document. Again, a 38-page document that mentions the words owner, contractor, and architect hundreds of times and talks about construction administration and how the three parties are going to play nicely together in the sandbox. Are there third-party beneficiaries? Could also be addressed in Article 8. Is this a rehab job with hidden conditions that may be concealed by existing finishes or otherwise not susceptible to observation by the contractor until they get out on site? What are the circumstances in which a contract like this can be accepted? Does it require a signature? What if it never gets signed but the owner pays? All things that could be included in Article 8 of the A101-2017, including what sort of credit and publicity is the contractor entitled to? Can they advertise the project on social media? Are they entitled to have signs on site? Can they disclose the project in beauty contests and future opportunities that they're pursuing with other owners of other projects? We've really just scratched the surface of what a well-advised contractor will consider when they're thinking about miscellaneous provisions, Article 8 of the A101-2017. Article 9 of the A101 talks about the enumeration of the contract documents. Again, capital C, capital D, contract documents is a term of art. And this is a place where the contractor is really going to want to be careful. It's always important, whether you're the owner or the contractor, to have clarity on scope and fee and timing and expectations. But sometimes it's the case that architectural drawings or engineering drawings are not as well developed as a contractor might like. Maybe it's because the design team's weak. Maybe it's because the design team was terminated and they're not involved in the project anymore. Maybe it's because the owner has decided to take the project in directions where the design team hasn't had an opportunity to complete their documents yet. Maybe it's a fast track project where for one reason or another, shovel is going into the ground before the documents are as well developed as they could be. And if you are a well-advised contractor, you're going to want to really take a look at Article 9, enumeration of the contract documents, and not shortcut it. You're not just going to want to say these architectural drawings and those structural drawings and those engineering drawings. If we expect that there's going to be an additional version of the documents or some of the documents, or if we feel that they're weak, there's absolutely room for a well-advised contractor to take a very hard look at Article 9 of the A101-2017, and make sure that the contract documents are described in a way that's fair, that doesn't unreasonably tie the contractor's hands when it comes to asking for change orders, whether they are for extensions of time or additional money or both. It's also worth considering whether there are any additional provisions that should be added directly above the owner's signature when you get to the end of the A101 after you've finished Article 9, sometimes in Article 10, which would be a new article that I would add myself. I will add certain miscellaneous provisions to comply with state law, certain consumer rights disclosures. These tend to be more important on residential projects than commercial projects, but there absolutely could be state law disclosures that are necessary in commercial construction contracts too, and I like to put those right above where the owner is going to sign their name so that there's no dispute about the fact that the contractor met their obligations in making those disclosures to the owner. In conclusion, the A101-2017 is an excellent document. I love it if I'm an owner. I love it if I'm a contractor. The basic deal for a contractor is setting out a fixed contract sum that can move over time with change orders leading to an adjusted contract sum. And you win as a contractor by bringing the project in under the adjusted contract sum. That's how you profit. And you lose if you blow past that adjusted contract sum and you have to pay more to execute the project than the owner is going to pay you. But all things considered, the A101-2017 is the simplest of the flagship AIA contract documents for use on commercial construction projects. It has many fewer pages than some of its related agreements, its cousins like the A201-2017, which deals with a different method of paying the contractor, a cost reimbursement up to a GMP method. I love the A101-2017 because it talks about a fixed contract sum that's adjusted over time. It tends to be less dispute prone because it's simple. And if you are a contractor that has architectural and engineering drawings that are complete enough for you to fix a price, subject to clarifications and exclusions, subject to certain allowances where you're not going to give a fixed price, subject to the fact that you may be entitled to price escalation or an equitable adjustment of your contract if there are industry-wide commodity disruptions. There's a whole lot of things that you can put in here to give you wiggle room, but still take advantage of the fact that the A201 is a very simple document, in my view, that tends to lead to win-win outcomes. Contractors receiving a fair price for good work, not getting stuck with a bunch of change order disputes, avoiding mechanics liens, and avoiding that arbitration and litigation that nobody likes. Whether you're the contractor or the owner, nobody wants to be involved in arbitration or litigation. And the A101-2017 is an excellent document for promoting happy owners, happy contractors, and projects that lead to win-win outcomes all the way around.